this might be a silly question. I can't think of a specific example in terms of mock trial and a previous case, but they often give us like an almost expert, like, you know, the intern at the lab, and he performed some test where it was pretty much he put a device in a box and the box told him some scientific value. And you know, the device, if calibrated correctly, it's just like black or white. It gives you like, you know, if I want to know how much this weighed, he put it on the scale and it said 2 ounces. And it's an improper opinion battle with, oh, the intern weighed it versus the guy who made the machine, and therefore his opinion or the results of this test shouldn't come in. How does 702 relate to that?
Okay. First, does everyone understand Michael's question? He's talking about basically like someone who who might be an expert but doesn't necessarily fit the mold of a classic expert. There are a number of ways you can deal with that. It's a pragmatic and logical approach that you would follow. The first thing that I would do is ask for permission to voir dire the witness. Does everyone know what it means to voir dire the witness? What does it mean?
Asking a question. Actually, I don't know. I know what voir dire is for a jury, so I figured I didn't know what you were talking about.
Voir diring for a jury is a little different from voir diring a witness. Does anyone know what it means to voir diring a witness? And it might be voir dire, I don't know.
Voir dire, you're right.
I think it's voir dire.
It's
Voir.
Voir.
Voir dire.
Do you speak French?
It's French.
No, but I looked it
Parlez-vous
up.
français?
No, not at all.
Okay.
But I just looked it up like a couple days ago.
Also,
Once we get to the south, like, it all goes out the window.
Well, when you're in the South, Yana, can I voir dire the witness? Alright, what is it?
Isn't it like asking them a question that kind of tests their competency to give an expert opinion?
That's exactly what it is. The beauty of a voir dire, if elegantly and properly performed, creates a disruption in the presentation of their case. Keep in mind, this is the other party calling their witness. In the context of the way the trial will go, either in mock trial or real trial, this is a big part of their case. Their expert is about to get on the stand. Their expert is about to sit in that chair, look the jury in the eye for about, 3 or 4 minutes straight, and tell them about all the schooling that they've gone to. That they went to Harvard or Yale or med school, law school, whatever it is, and all the experience that they have. Build up all this credibility. And then they start going into the facts, how they're involved in this case, the information that they reviewed, and then they reach the big point where they're about to give this opinion. And that's where you ask to voir dire the witness. As a cross-examining attorney, you have to do this before they actually start giving their first opinion, because once they do, you lose the opportunity. The way it's done is as follows. Dr. So-and-so, have you had an opportunity to formulate an opinion as to whose blood was found at the scene? Yes. Now, can you please tell the jury, objection, Your Honor, permission to voir dire the witness. Right there, stop them mid-question. What this does is allows you, if the judge permits you, allows you to get up, begin your cross-examination in the middle of their direct examination, while this schmuck of an attorney stands there over in the corner with his hands behind his back, waiting for you to finish tearing up his witness. That's why it's so beautiful. That's why it's so effective. Now, your voir dire should go something as follows. Now, Dr. So-and-so, you claim that you're an expert in the field of toxicology, isn't that correct? Yes, of course, I went to school. I understand that you went to school, but my question is more specific than that. You've actually never been published on the topic of toxicology, isn't that true? Well, yes, but I've gone to school. I understand you've gone to school, Dr. So-and-so, but you've never written any treatises, correct? You've only read the treatises of others. You've never developed your own methods, isn't that true? Well, I've been using tried and true methods. So that's a yes. You don't have your own methods. You, specifically with regard to this case, you actually only conducted a test on 2 control groups. Yet you would agree that, using the same example that we were talking about before, yet you would agree that normally you would run a test with 3 control groups. And you used 4 samples in 5 test tubes, yet you would normally use 6 test tubes with 7 samples, or whatever the numbers are. You draw the distinctions. along the lines of Rule 702. Normally, you're going to hit hardest on the application of the facts, of the application of the reliable principles and methods to the facts in this case. That's normally going to be the center of your voir dire. I actually skipped a part. If the judge permits you to give a voir dire, you begin it by saying the words, "Here begins my voir dire." You end it with the words, "Here ends my voir dire." The reason why you begin it and end it like that is because if given in real life, it's done outside the presence of the jury. If you have a decent trial attorney sitting here scoring you, he or she is going to, if they don't know enough about mock trial, which is likely, they're not going to understand why you're doing this in the middle of, while you're beginning your cross-examination, in the middle of their direct in front of the jury. So by using that language, you are indicating to those judges, this is what you would normally do outside the presence of the jury, but because this is a fake case, we can't excuse the judges. So you begin it with, here begins my voir dire. You start asking the questions. Your questions can only relate to their qualifications as an expert. It can't have anything to do with bias, credibility, involvement. It only relates to their capabilities to give an expert opinion under Rule 702. If you screw it up, you will lose that round. It is incredibly dangerous. Do not do it incorrectly because you will look like an idiot if you do. I've done it both ways. I've done it right and I've done it wrong. I was very, very sad when I did it wrong. It was not a good day for me. Don't get trigger happy with it either. Don't do it unless you have it already written. Don't do it unless you already are prepared for it. Don't do it on a whim. Don't do it because you think you got this witness by the cojones. It's just a bad idea to do it on a whim. But it's incredibly effective and just a beautiful thing if done correctly. The last part of this whole voir dire process is that after you finish your voir dire, before you go back to your seat, I don't care what the Midlands rules say, you move to strike the witness as an expert. The rules say you can't make motions in court. I don't care. Because you won't have an AMTA violation imposed on you for making a motion. The judge is going to be like, well, no, denied. But the thing is that it's not complete. In these scoring judges' minds, it's not complete unless you move to strike that witness after your voir dire. What are you doing if you're not trying to strike them as an expert? Right? I mean, like it's like going out, buying someone a present, putting it in this really nice box, and leaving it open when you give it to them. Like, what's the point? Why would you go through all those steps if you're not going to actually go all the way? So you start with here begins my voir dire. You ask the foundational questions under 702. You end with here ends my voir dire, and your last words are, Your Honor, we move to strike Dr. So-and-so's testimony as an expert witness under Rule 702 as he or she lacks the qualifications under the requirements or under the rule. That's it. Like I said, only do it if you know what you're doing. Michael.
Good, thank you. One last thing.
Yeah.
If there's a scientific test that is pretty much black or white, it's yes or no, is it an opinion? And do 701, 702 apply?
That's a really good question. So basically you're asking is, well, just because something's scientific, and just because something seems to express a position, doesn't necessarily justify it as an opinion. Again, the simple test to determine whether or not something is an opinion is if grammatically the sentence would make sense if you put the words "in my opinion" in front of whatever it is the witness said. It's practically impossible to do that in your head in the time required to make the objection, but that's the answer. So, if the statement was, the test revealed that there were 34 micrograms of cocaine in his blood. In my opinion, the test revealed that there were 34 micrograms of cocaine in his blood. Doesn't make any sense.
Right. So if I was the directing attorney eliciting that information from the witness and they objected improper opinion to a very dry numerical value of result, would it not be an improper opinion?
My response would be, Your Honor, this is proper testimony and it's not in the form of an opinion. Dr. So-and-so is stating factual observations that he made. At this point, Dr. So-and-so is not testifying under Rule 702, but rather under 701. It's a rational perception that he made while administering this test. Okay. It's numbers. Right. All right. I'm still not done answering your first question though, because remember I said that there are two ways to attack that.
Mm-hmm.
If we recall before we went on this voir dire tangent, the question was how do you deal with it? How do you deal with a witness that's not qualified, basically, right? If you get shot down at voir dire, or if they let you voir dire and they don't strike it, which they won't, you need to make the appropriate objection when the time comes in the direct examination, which is normally going to be the next question, if you timed your voir dire right. The objection is improper opinion. That's the appropriate objection. So, if you recall, the question would be, now, in your opinion, or do you have an opinion as to who committed this crime or whose blood was found at the scene? Yes, based on my observations and my experience, I found that, in my opinion, it was likely the defendant's. Objection, improper opinion. Your Honor, it's probably going to be flat out overruled. You have to make it. If you get the chance to argue it, the way you would argue it is basically the same way that you would have argued it in your voir dire, but in a shorter, more concise manner. So if you recall, my voir dire was saying he's never been subjected to peer review, and in this case, he didn't really apply the principles and methods faithfully to the facts in this case. So your response, objection, improper opinion. May I be heard, Your Honor? Your Honor, as we've just established no, you can't say that because that would have been out to the President's jury. Your Honor, it's our understanding that Dr. So-and-so has not faithfully applied the facts, reliably applied the facts and principles, has not applied the reliable principles and methods to the facts in this case, as he would in other situations. If I may be heard outside the presence of the jury, Your Honor, and then go on to explain, normally he would use 6 test tubes, and today he used 5. Normally he would use 4 control groups, and today he used 3. Whatever it is, but the point is you restate the points that you made on your voir dire in a shorter, more concise manner. Don't bore the judge because they probably just heard everything you said, but that's the way that you would appropriately object to improper opinion. If you lose that objection, ignore it. You fought as much as you can, especially if you were permitted to do a voir dire. You've made your point. The way judges determine whether or not you're objecting too much is keep in mind that if you're in real court, everything's on a record, everything's on a transcript, every word that everyone speaks is always written down. So the judges that are scoring you are thinking back, okay, if we had a court reporter here, would a judge reviewing this be able to be like, yeah, he made his point. He preserved that point. He can now appeal on those grounds. In other words, did you so eloquently and clearly state your objection that if this case didn't go your way, you could appeal on those grounds? So, don't beat a dead horse. You did a voir dire and you objected again. At this point, the judge isn't going to rule in your favor. He or she wants to hear this testimony. Give it up. Don't annoy them.
Would you suggest then, if you don't get the voir dire and you don't get the improper opinion, and you weren't able to question in the voir dire, like you said, permission to voir dire didn't, no. Put those what you would have done in the voir dire in on your cross examination.
That's exactly it. That was the third part of it. That's the third way to attack it. If conditionally, if you get the questions out on cross, because now it's important to know that your voir dire is considered part of your cross examination. Just like your redirect time is deducted from your direct examination time, they count down the time that you spend on voir dire from your team's cross-examination time. So, if you started asking those questions on voir dire, don't re-ask them on cross. But if you weren't permitted a voir dire, make sure that you do ask them on cross.